And our guest this hour is the Honorable Justice Professor Joel Ngugi. He is a judge of the High Court and presiding judge of the Nakuru High Court. He is also the chairman of the National Steering Committee for the implementation of the Alternative Justice Systems Policy.
It's a mouthful.
I'm done. Chairman.
Go home now.
Your work is done for the day.
Yes. Yes. Goodness. It's good to have you on the show.
Thank you. I'm glad to be here.
Now, City will ask that question.
Yes.
How should we refer you? How should we call you? Your Honor, Honorable Judge, Professor,
Justice Professor.
And you forgot Baba Kioni. Sylvia's husband.
Bas.
All those are mine.
Okay.
Mtoto wa Mama Lucy. Yes.
Good ones.
Yes.
Good ones, Prof. You recently moved now to the Nakuru station.
Yes.
How are you finding Nakuru?
Nakuru is great. It's not that recent, actually. It's already 3 years since I moved to Nakuru.
To Nakuru. Yes.
Nakuru is an up-and-coming city. It has everything that you ask of a city, yet everything you also ask of a more laid-back rural place. So I'm really loving it in Nakuru.
Great.
And it's not too far from Nairobi, so you can still spend your weekends in Nairobi. I'm hoping the Chief Justice is not listening to this. Because that might provoke her to move me
move
from
you
Nakuru.
further.
She might be thinking I might having too much fun. Yes.
Move you further from here and take you, know. So recently the Chief Justice rolled out these plans. But even before that, it was a whole conversation about alternative justice systems that had taken place. You chaired the task force that led to the birth of this policy.
Correct.
So tell us about alternative justice systems. What's that all about?
Okay. Thank you. So let me start by saying I think in this country, what we're trying to do now is to change conversations about justice. For a very long time, I would say since the advent of colonialism, we've pursued justice in this disputational mode, in this adversarial mode, which we were taught and which we then sort of became very good at, and it superimposed our systems, our organic systems, which still exist. But when we talk about justice today, we still think of justice in that adversarial disputational mode. And we think that is a very unnatural way, a very inorganic way to think about justice. And we think a lot of the problems that we see in the justice system are caused by this way of thinking about justice. So the aim here is to try and bring back our organic plural systems of justice that have existed since time immemorial, that are more natural to our people, and I believe that lead to better justice. We say to Kenyans, when you think about health, your health, you don't necessarily think about hospital. In fact, you think about hospital when you are unhealthy.
Yep.
But when we think about justice in Kenya, we think about the court.
Yes.
It should be the other way around.
And jail.
Yes, and jail. And that's not justice. I think we need to be thinking about justice in the same way that we think about health. We don't go to the hospital to get health. We get our health in our own homes, in our own communities, in what we eat, in what we do every day. And that has to be about justice. So justice has to be palliative. And that's what alternative justice systems is. And that's what we want to take back most of the cases, most of our conversations about justice. And I believe we'll have a much better society if we go there.
Do I almost hear you saying, Prof, then that you need to include community in this justice seeking or justice making? Because that would mean when you're looking at health, then you're looking at the things that you eat every day, you're looking at the exercise you do every day. So if you're looking at justice, the communities that you interact with on a daily basis to make sure that things are, at least at a rumble level. Is that what you're saying? Bring in traditional communities to be able to sort it out?
Absolutely. That's what we're saying. And luckily for us, it's not just us saying. Constitution of Kenya 2010, in its genius, said it already. So in Article 159, actually starting with Article 2, even in delegating judicial power to the judiciary, it's very clear that the people remain sovereign, even in the justice sector. And then in Article 159, it still comes back and tells us that we must promote alternative justice systems as perhaps the most superior way of resolving some kinds of dispute, perhaps most kinds of disputes. So yes, it's a question of going back to the communities, promoting their own systems of justice, promoting their own conversations about justice. That's what this is all about.
But then communities are different.
Yes.
That means that one community's approach and conversations around justice may not be necessarily the same in another community. So does it mean that also looking at each community handling its justice its own way, or should there be a common thread?
Getting right to the depth of it, Eric. Yes. So two things. So first of all, in Kenya today, when we talk about alternative justice systems, we are not necessarily talking about my grandfather's, your grandmother's African customary law necessarily. So one of the things that we realize is that one, a lot of the justice that is practiced every day, the quotidian justice in the community, even in communities that we might think people of the same community live. So if you go to deep in Il Kaputei in Masai, and you think there are only Masai people there, you will find that a lot of the time when they are speaking, they're having conversations about justice today, you will find that it's infused with a lot of ideas about human rights, a lot of ideas about that's already in statute law, a lot of ideas borrowed from the Kambas, and so forth. So that customary law has really grown. So when we talk about alternative justice system today, we're not necessarily talking about it in its anthropological sense. We are saying about systems of justice that are organic, that reside in the communities. Sometimes they use some African customary law that has already been infused with modern notions of law or human rights or constitutional norms and so forth. And sometimes they just use common sense. Sometimes they just use logic and so forth. So the notion of alternative justice systems that we are deploying now, and as it's comprehended in the judiciary policy on alternative justice systems, basically comprehends all those forms of alternative justice system. If a certain group of people prefer to have their own AJS mechanism that binds them because of their anthropological lineage, so be it. The Constitution allows it. But if they also come together because they live in a neighborhood and they decide that we're going to be resolving our disputes this way in this neighborhood, that's also allowed. If they decide they're going to be resolving their disputes in a particular way because they belong to a particular church, that's also allowed. And the Constitution in Article 159 tells us promote all those forms. The only proviso that the Constitution gives us is that all those alternative justice systems, both in their processes and in their outcomes, must be undergirded by constitutional values in the first place, and in the second place, they cannot violate the Bill of Rights. So the Bill of Rights is supreme, and it is the basic minimum that you are asking. That's the basic minimum, both in terms of substance, but also in terms of process. If it meets those standards, then we as a judiciary, we have an obligation to promote those justice systems and enforce any awards that they come up with.
And if it doesn't?
If it doesn't, then that's why the role of the judiciary in Article 159 is to promote. So promote is human rights lingua. It means at least three things. It means, number one, you respect where they promote the norms of the Constitution and the values of the Constitution. But it also means that you protect. So you protect the victims where they do not. So where they do not comply with the constitutional values, then that's where the judiciary, in its interaction with those forms of alternative justice systems, can say the outcome here does not comport with the values of the Constitution, so it will not be enforced.
What role does the judiciary play in the structuring of the individuals who will play this particular role in the communities?
Okay. Thank you, Muga. So this was almost rehearsed because I talked about human rights lingua and I was unbundling what promoting means. And I talked about respecting,
Yeah.
I talked about protecting, and your question takes me to the third aspect of promoting, and that is transforming. So one of the roles of the judiciary is also to transform those alternative justice systems. So it's not just to accept them as they are, but to infuse the human rights language, human rights norms, the expanding norms of human rights, and the expanding corpus of human rights worldwide, globally, as supposed to be infused in these alternative justice systems in the interactions that the judiciary has in them. So the role of the judiciary, as we see it and as we've interpreted it, means, one, to come up with a policy that guides these alternative justice systems. That's why we have the alternative justice systems policy. It provides some basic guidelines on some of the basic minimums that they should meet. But also, the policy provides for an approach, a pedagogical approach that is really didactic of engagement with these mechanisms, so that in the engagement there is cross-learning. There's a lot that we can learn from these alternative justice systems in our formal court systems. So we learn from them, even as we teach them some of the basic minimums that we know from the Constitution, so that in that cross-learning, we transform each other. We transform the systems as they transform us. Because nobody said that we are the gurus of justice.
Let me expand on this.
Yes.
The alternate justice system
Yes.
that one considers, well, I consider and I know is structured, say, the arbitration, mediation. However,
Yes.
for the longest time in community settings,
Yes.
the chiefs,
Yes.
the elders, these were the pillars of this particular system.
Yes.
Now, why I asked about the judicial participation in this is there not a need for some of these individuals to be trained, to get additional training so that they are grounded
Yes.
in some of these things which are nuanced in the Constitution, stated and understood by those who are in the judiciary, so that the issue of a diversion from what the Constitution seeks to pursue and entrench is minimized?
Yes. Yes, you're absolutely right. The word you use is train. In Paul Freire's tradition, I do not necessarily call it training because I see that as very sort of top-down. I see it as engagement. That's what I call didactic engagement. So I'm borrowing from the pedagogy of the oppressed. I mean, so this is bottom-up, right? So what we don't necessarily say that we go and train. We go and say we engage with them. We engage with them so that in the engagement they get to learn as we get to learn. There is a lot that they'll teach us, even as we teach them about the constitutional values. So it is about the engagement. And yes, the policy is all about engagement. It's about engaging with them, getting to know what is it that they do, what are the societal problems that they're dealing with, how are they transforming them into legal problems, and then how are they resolving those legal problems, and then perhaps suggesting some of the creative solutions that come out of the Constitution. And through this engagement, Muga, we've already been able to make a lot of headways in a lot of places. So if you go to, we just launched the AJS model in Kajiado, and you might imagine, for example, the Maasai would be a very patriarchal society. They would be very opposed to the idea of having female elders.
They'd be traditional.
And so forth. And you would be surprised that one of the things that they were very, very open to is the idea that, yes, females can be elders. Yes, the youth can be elders, and so forth. So if you watched...
Actually, Judge,
yes,
let's
please.
let's just do this.
Yes.
Give us that example
Yes.
of the one that you launched in Kajiado.
Yes.
So what is it? For people who just, okay, so we're hearing alternative justice system. What is it that you launched in Kajiado? Is it a court? Is it a council of elders? What is it?
Very good. Thank you. What we launched in Kajiado was a model of an AJS system that is homegrown in Kajiado. It is it's spearheaded by 5 agencies, but I would say the author of the model is the county government. So the county government of Kajiado is worried about economic development in Kajiado. And one of the things that hampers economic development is in Kajiado is the land disputes that affect Kajiado because of its proximity to Nairobi metropolis, but also because of the historical immigration into Kajiado. I'm from Kajiado County myself, born and bred. My parents went to Kajiado back in the 60s. So there are a lot of immigrants in Kajiado who have bought land from the Maasai people who traditionally have been pastoralists. A lot of the immigrants practice sedentary agriculture and so forth. So there have been disputes which have hampered economic development. So the county government realized that if we're going to move social development to the next level in this county, we need to resolve these disputes, and courts are not the way to go because you will bog down the courts. These things will remain there forever, and even when those issues go to court, sometimes they'll go to court and the court will come up with its judgments and rulings and so forth, but enforcing them socially becomes very problematic.
Right.
So they decided, I think the way to do this is, why don't we revivify traditional ways of resolving these disputes? And when they say traditional, they don't even mean Maasai, they just mean African.
Right.
There is something that's so common about how Africans talk about justice and talk with each other or have conversations about justice with each other. So what they decided to do was to go the traditional route of saying in Kajiado there are 11 sub-tribes of the Maasai. They are called sections. I don't know if you knew, but the Maasais actually have sub-tribes. They're called Iloshon among the Maasai. And so they decided they'll have 9 sections for each of the Maasai sections to resolve some of those disputes that come within those sections. And then they will have one cosmopolitan one, which is mainly found in Ngong, where it's very, very cosmopolitan. And a lot of the land disputes that will be emanating in those places will be resolved by the elders. So they carried out an exercise of recruiting elders, panels of elders in each of these 10 sections. This exercise, we supported the exercise with technical expertise, but it's supported by the Food and Agriculture Organization, which of course is interested in the question of food security, which is also hampered by the disputes to land. It is also supported by the National Land Commission, which has a constitutional mandate to resolve land conflicts before they come to court. And then, of course, the judiciary, which is interested in not having these cases come and bogus in court. So what we were launching in Kajiado on Friday was these homegrown, autochthonous dispute resolution mechanisms where they will resolve their own disputes. And where the court comes in, the court has come in Kajiado through the Court Users Committee, where the court is basically pledging, if you go and resolve your disputes there, we will respect the outcomes of those disputes. When they come to court, we will not relitigate them. We will just check for procedural propriety to make sure that the constitutional norms of procedure have been met. We will also check for what we call proportionality. Proportionality analysis is just to say, have the substantive norms of the Constitution been adhered to? Okay. And if those two are checked, then we will just enforce the award as it is. We will not litigate.
Okay, let's take a break.
Yes.
And then we come back and you give us a little bit more about this. We have in studio with us the Honorable Justice Professor Joel Ngugi, Judge of the High Court of Kenya, presiding judge of the High Court in Nakuru, and also the chairman of the National Steering Committee for the implementation of the Alternative Justice Systems Policy. Now I can say it now because I understand what we're talking about. Right? We are live on KTN Home, on Spice FM and online, the Situation Room on Spice FM, online and on KTN Home. In the room this and every weekday morning is Nduoko, C.T. Muga and Eric Latif. Joining us today this hour is the Honorable Justice Professor Joel Ngugi, Judge of the High Court and also Chairman of the National Steering Committee for implementation of the Alternative Justice Systems Policy. As we're going to the break, Judge, you're explaining to us what, for example, was launched in Kajiado, which is to be replicated around the country. Maybe you can explain to people, is it this system going to be dealing with both civil and criminal cases, or is there some distinction between there are things that cannot be handled here and others that can? Or because we've had many complaints of unajua walisema hii mambo tutatue kinyumbani, and assuming that is what the alternative justice system is, And in many cases, for example, in Sexual Offences Act, complains that people went to talk kinyumbani and the victim is a child. So how does this work?
Okay. Two very good questions, which I want to just take some time to respond to because they are very crucial. First, what was launched in Kajiado is not really what will be replicated throughout the country. What was launched was the model that Kajiado has chosen, Kajiado County, and has chosen it because of its unique circumstances and where the justice conversations in that county has taken them. And the main issue there is land. That is the main issue. Other counties and other places might choose different ways of addressing what their most important justice conversation is. Okay. For example, in the pilot stage, when we were doing the task force, when we were writing this policy, one of the places we visited was Othaya. And Othaya has a very interesting homegrown AJS system as well, which we studied as a pilot. And there, the main issue was not land. The main issue was Ngugi, actually. It was just these youthful gangs and so forth. But they were showing themselves, they were registering in the in the justice system as criminal cases. Drunk and disorderly, preparation to commit felony, burglary, just fighting and so forth. But the people in Othaya realized that they are sending most of their young people to prison. And there was a bigger conversation to be had, which could not be laundered using the criminal justice system. So they use the alternative justice system as the way to have that conversation. And Othaya is one of the places where they almost completely eliminated the Ngugi problem. And there were no extrajudicial killings. There were no killings. There was no mob justice. They talked it out using the court users committee as using its convening power. So that was the main problem there. Okay. Kajiado has a different problem. So different places will come up with different models for resolving their disputes. All the judiciary promises in this policy is whatever homegrown system you come up with, whichever kinds of disputes you decide would be cured or will be solved or will be resolved in those mechanisms, we will promote, we will respect, we will protect, and we will help you transform. That is what the policy says. Okay? So now we come to the question, are there some kinds of disputes or controversies that are off limit that will just not be handled there? The answer is yes. But that answer is not answered categorically with a bright line rule. It is answered with a principle. The principle that is applied to determine if a case will be resolved, can be resolved fruitfully in an AJS system or not, does not depend on whether the case is criminal or civil, constitutional or statutory. What it depends on is the application of what we call the agency principle. The agency principle asks the question, can you ask of the two disputants who are approaching the mechanism, can you say that they each credibly, voluntarily, and in the exercise of their own agency, chose to be in that forum? That's the first question. That's a positive test.
Okay.
If you can say that in the exercise of their agency and human autonomy, they credibly and voluntarily chose the AJS system, then you have an obligation, a constitutional obligation, to let them proceed in their case in that forum.
And this is all parties?
All parties. Then secondly, you have to ask the question, is there any statutory or constitutional criteria that ousts the jurisdiction of the AJS mechanism? That's a negative test. If there is a statute that says that case cannot be heard in that forum, then the inquiry ends. Okay. But going back to the first one, which is the more complicated one, it's an objective test. It's not a subjective one. So if you come, for example, this is why the cases involving children, for example, will never be heard in the AJS mechanism through the application of the AJS principle. Because there's no way you will be able to say that through the application of the agency principle, that party credibly exercise their agency, and they chose that forum. Most cases involving violence against women will also, most times, not be applicable in the AJS system, because if a woman has already been has been assaulted or has undergone violence in a system that might be patriarchal, then you have to do an objective analysis and say, can we really say that this woman has credibly chosen to be in that in that mechanism? So through the application of the agency principle, then we are able to really sieve which are those cases which then can and should be in that system, and which ones should not be in that system. It's a really simple mechanism. Of course, hard, complicated in some few cases, but we say in law that hard cases make bad law.
Right.
So we are making cases for the majority of cases.
Okay.
Yes.
So I'm looking at a system whereby the police, as a service, play in the expansion of justice, right? So as it is currently constituted, there's a system whereby if a crime has been committed, most likely it has been reported to the police then take it on before it finds its way eventually at the courts, right? Now, looking at AJS, what role, if any, would they play, knowing very well that they must go through the courts? As a service, they have to go through the courts, constituted to do so.
Okay.
Will they play a role in AJS as well?
Yes, very good question. And you would have made a very good student. So I would say this. First of all, if a matter is reported to the police station as a crime, as an incident, there is no requirement that it must end in court. There's no legal requirement that it must end in court. In fact, the police and the prosecutor are one of our foremost targets in the pedagogical engagement I was talking to Muga about, because they make a lot of decisions that have a lot of impact on the justice system. In our own study, we found that, in fact, it's in the police stations where let me say a lot of AJS takes place. Someone reports to court, and we found it's in many cases where people report a matter to court, but not because they want the matter to end up as a criminal case. They report because they want to open avenues of conversation. So they want to use the police as a convening power, as a convening authority, to call the other person and say, why are you doing this? Why did you encroach into my dispute? Why is my son coming home and drunk and threatening to beat me, and I'm the father, and so forth? They don't want that son to go to prison. Okay? If you're a policeman and you're not well trained, you would think, okay, I'm just going to write up a charge sheet. I will take to the prosecutor, and the prosecutor, again, if they're not well trained, they will think, I'll just sign this and I will take it to court. And then when they come to court, you find the father really pleading. The same complainant is the same father who wants to put bail for the son. And they're saying, you're sending my son to custody, and that's not what I intended. I just intended us to have a conversation. So we are going to be training policemen. We're going to be training chiefs. We're going to be training prosecutors and so forth on really the essence and the essentials of alternative justice systems, and really what our criminal justice system should be doing. Our criminal justice system should not be put in motion just because something that is cognizable as a crime has been committed. It is not always the case that it should be. That is why, if you look even at the prosecutor's policy, one of the things they have to use two tests to determine whether to charge or not. It is not just that a crime has been committed. The first question they ask is, first of all, there's evidentiary standard. Do we have the evidence? But the second one is public interest standard. Is it in the public interest for me to use public resources to charge this person and prosecute them? Or are there other mechanisms that can be used to deal with this problem?
You know, from where I sit,
Yes.
the judicial system is introducing a brave new world. A good one. But there's a concern.
Yes.
You mentioned in passing, but I'd like to dwell on it a little more. Ensuring that whatever judgment, whatever decision is arrived at is actually implemented. Whether it is at whatever level.
Yes.
Because one of the problems that we read about,
Yes.
even with court rulings,
Yes.
Enforcement.
that's it.
Yes.
Judgment we hear, lovely. Thereafter,
Yes.
the thing that I find painful,
Yes.
most painful, is when people are given compensation through a judgment of court.
Yes.
Years later, it is still a story. Or cases of land disputes,
Yes.
like say the issue of the Solio Ranch. Man, 48 years going, thing is still in court, and you're wondering, people have died. People who started this thing have died.
Yes.
And that's so that we don't go to this history that I'm referring to,
Yes.
what is the judicial system going to do?
Okay. So, Muga, I think you've made one of the most passionate arguments for alternative justice systems.
Yes,
Because what you have done here is to say, so if you look at our justice needs survey, which was commissioned by the judiciary, it says that 79% of all disputes that Kenyans had in the last 4 years, 79%, they didn't bring them to court. 79%. They took them somewhere else. Okay, so let me start a step before. So you've had people saying that Kenyans are very litigious people,
Yes.
right?
I've heard it.
So we have empirical proof for it. The empirical proof is in the Justice Needs Survey, which says that, so in the last 4 years, 81% of Kenyans who felt aggrieved by a decision or an action of another person decided to take action. 81%. That's an extremely high number. Okay? If you do Tanzania, it will be about 50%. Okay? Wale wengine tu watasema, nimeachia Mungu si adhmani. But in Kenya, 81% decided they are going to do something about it. Okay? So that's why we actually say Kenya is litigious. But most of them did not actually come to court. 79%, again, this is empirical, decided to go somewhere else. They decided to go to Wazee, they decided to go to their pastor, they decided to go to the police, but it didn't end up in court. They decided to go to the chief, they decided to go to their estate association, their clan association, whatever. They decided to go somewhere else. Only 21% ended up in court.
Did you even go to witch doctors?
Yeah, I'm sure.
Okay.
I'm sure. So only 21% end up in court. The problem of enforcement of judicial decisions that we are talking about are this part of the 21%. And we're already tired about talking about it. It's already exhausting. We're already seeing how much it's eroding the confidence of the public in the court. And that's only the 21%. The research shows that 96% of all decisions that are made outside court in the alternative justice systems are adhered to without the need for any outside enforcement. 96%. So 96% of the 79% who went to other alternative justice systems did not need me to sign an order saying that you must do this. 96% of them did not need to involve a police with a gun to go and enforce that order. They didn't need anyone to go to jail to enforce that order. They just did it. It is self-executing. So if we're going to really have an optimal use of our scarce resources that are being directed to the justice sector, then this is really the way to go. Then we can really focus on the 21%, which by the way is already too much for the judiciary. If you look at the 21%, last year we're talking about a total of 484,000 cases filed in court. 484,000 cases translates to about 800 cases per year per judicial officer in Kenya today. It's impossible for a judicial officer to complete these 800 cases anyway, even in a year. So the backlog is likely to continue rising unless we do something about it. And so we need to reduce the number of cases through these conversations that is palliative, this conversation that diverts cases to really that fits the fast to the forum, to the correct forum, so that the few cases that then end up in court, we can spend the appropriate amount of time dealing with them. And then we can pursue those who disobey court orders with singular vehemence.
Right.
Yes.
So before you go to that, which I know Eric wants to
Yes.
jump on in
Yes.
terms of those who disobey court orders, the very quick one, you talked about limited resources. And
Yes.
so obviously it's a thing.
Yes.
So now if we're looking at AJS going to traditional community leaders and elders and such, will there be compensation for them? Because that means that now, some of the time is going to be taken up in sorting out this. Will there be compensation for them? And then who's to ensure that they will do this in record time and make sure that these cases are dealt with so that we don't go back into the same rut
Right.
that you've talked about of time being sapped?
Right. So two things. So first of all, the approach we've taken now is that if something is not broken, don't fix it. Okay? So 79% of these cases are already being heard and determined effectively in the AJS system. Okay? Why would we want to fix that? It's not broken. It's working. Fixing that means we start going and then telling them, hey, you've been deciding these cases now. What do you think about us paying you for resolving them? We don't have the money to pay them. They're already doing it. They're doing it as a sense of responsibility.
So carry
People
on.
do this all the time. So we're just encouraging people to do it. And what we want to give them is that civic sense of pride in doing what they do, that they know that they are participants in the justice in the justice sector, and that what they are doing matters. I think that is more than they want. And when we've talked with them everywhere in the country where we've gone, they're quite happy to continue doing it. They need some of them ask for very basic facilitation. They need places to buy, they need money to buy just a book where they record the cases that they've
stationery
had,
and such.
and pens and so forth. And some of them are in the structured mechanisms, like in Kajiado, they would need a fare, bus fare, to go to the venue.
Sure.
Where and so those are being organized in different settings and so forth. But the judiciary is not saying we have this ton of money which is available to give to the alternative justice systems. We are saying, please come up with your own justice systems that work, that you're proud of, and we will promote them, and we will respect the outcomes of those justice systems.
There's something you mentioned, Justice Ngugi, and this was about the backlog. So this 24% that end up in court,
21%.
21% that
Yes.
end up in court,
Yes.
and we still complain about backlog.
Yes.
You participated in conversations about the active case management.
Correct.
So first of all, what's the cause of the backlog, and what are you currently doing to address this, to make sure that once I get into the system, I call it the system.
Yes.
Once I'm arrested,
Yes.
and then your case has gone to prosecutor, and I'm brought before a magistrate,
Yes.
I am in the system.
Yes.
And the community has already judged me, and everybody has, are these guys in court?
Yes.
How long should it take for me to get out of this system
And there's no
and get
exit.
get my justice?
Very good question. Let me answer that question in two ways. So first of all, let me say, I believe we need to reduce the 21% that's coming into court, because that's already overwhelming the court system. So a soldier report by the judiciary, our backlog stands at 617,000 cases, roughly. Okay?
How many?
617,000. That's the last soldier. Okay, and I said every year, or last year, we had 494,000 cases filed. So you can expect every year the cases will continue increasing, not reducing. The only dip we've seen was last year because of COVID. So COVID had at least one positive externality. But we expect in the future those cases will keep rising, not reducing. And given the number of magistrates and judges we have, it's a finite number. We have about 600. So if you divide 484 to 600, you get about 800 cases. They can't finish those 800 cases. So there is a need, first of all, to reduce. The conversation we're having about AJS is one way to reduce even the number of cases that are coming to courts, because we can't keep doing the same things and then expecting different results. But secondly, of course, we also need an increase in the number of magistrates and judges. That's a conversation I know JSC is pursuing with the executive. That's definitely needed, especially given where we are going. But thirdly, to return to the point that you brought, is we also must change how we do things. as a judiciary. So this is a conversation we have been having for some time now, but we are now reaching the peak of that. And I see that the Honorable Chief Justice Martha Koome has now made it one of her pillars of her blueprint. We must change our work methods. That is what active case management is. We must train our judicial officers in how they manage the cases that come before them, how they move them forward, how they manage their dockets, and so forth. We must change our systems of accountability. We've gone so far in Kenya. I think we really are leading globally in terms of just accountability for judges and magistrates, in terms of our collecting our statistics, in terms of performance management, in terms of accountability that we have in place. Now the next step is to holding judicial officers accountable for their docket. So that once you've been given a case, and we are 4 in a station, you don't just say, hey, hii file ni kubwa, hii amuga ni kubwa sana. So what I will do is I'll just make sure it doesn't proceed today so that next week it will go before due. And then she can deal with the mess. So I look for every reason to adjourn. And of course, there will always be one lawyer who wants a case adjourned.
Yeah.
Right? So then I will quickly acquiesce to the adjournment so that next week I make sure that it doesn't come back to me. It goes to Ndu, then who has to deal with it and so forth. So now some of the changes we are making, and in Nakuru, these are changes we've already established. They have been in place for the last 2 years. Once a case comes in, it's randomly allocated to a judicial officer. It's yours. It's your baby. Ukue mgonjwa, uadjourn, uende wapi, urudi, unaikuta. Okay,
what if you're transferred?
Now, and until you transferred, but remember, there is now the system of performance evaluation. You are reporting your numbers. You're reporting your numbers. The Chief Justice is looking at your numbers. The Chief Justice has a place where she's saying, how many cases has Justice Ngugi decided this month? So with that pressure, and with all those cases coming to individuals, and you're individually responsible for them, I believe we're going to see a lot of changes. Sure. Yes.
You know, there's a discussion about the other agencies within government that are part and parcel of this system. Okay?
Yes.
So much as we talk about the judicial system and what they need to do, there are certain things that are beyond them.
Yes.
What conversations do you think you ought to have with other agencies so that in reality, from their end, that particular burden is also reduced?
Absolutely. That's a very good question. That you've asked, because the justice system is as weak or as strong as the justice chain. And the justice chain, especially in criminal justice, is very long. It starts with the investigator, it starts with the police, the investigators, the prosecutors, the prisons, the lawyers, to the judicial officer. So there are very high level conversations. The conversations are taking place at 2 different places. At the highest level of policy making, there is a National Council for the Administration of Justice, chaired by the Honorable Chief Justice. That is where a lot of the policy issues that affect the different agencies take place. And then at the local level, we have the court users committees. Court users committees are a cascaded replication of the National Council for Administration of Justice, both at the county level. So at the county level, as a presiding judge, I chair the county CUC, which again brings the heads of agencies of the different stakeholders in the justice system. And then you go down lower to the magistrates courts level. There is also now the magistrates courts users committees, which again brings together stakeholders at that level. So those conversations are taking place at those 2 levels, and what emerges from the magistrate CUCs comes to the county CUCs, then we cascade them up to the National Council for the Administration of Justice. So that when we are engaging constructively in that manner, then we can be able to systematically see where the bottlenecks are, and then policies can be fashioned and crafted at the National Council for the Administration of Justice, and then cascaded back down to the CUCs.
Justice Ngugi, thank you very much for joining us today. Justice Professor Joel Ngugi is a judge of the High Court of Kenya. He's a presiding judge in the Nakuru High Court. And recently, during the review of the Judicial Performance Review, your station was voted the best, was found to be the best. Congratulations, Judge.
Thank you.
Congratulations, you and your team at the Nakuru station. Good stuff that you're doing there. And thank you for joining us. Come again soon.
Thank you for having me. I enjoyed it.
We like having these conversations, talking about judiciary Thursdays. That's what Chief Justice Martha Koome said. On Thursdays, Kenyans would like us to have a conversation about justice. And we said, yeah, that's a good thing, because we'd like to have a conversation about justice, how we can access justice better, how we can make sure that cases are speeded up, how we can remove the backlog from the courts. And today's conversation was about alternative justice systems. Justice Ngugi, sema kwaheri, ambia wananchi wa Kenya kwaheri.
Asanteni, kwaherini. Thank you for talking to me about justice. We hope to see you in a place near you to talk about alternative justice systems and changing the conversation about justice in Kenya.
Indeed. We've been live on KTN Home since 7 a.m. It's now coming up to 9. The conversation continues on Spice FM.